Good afternoon. I call the Labor, Industry, Finance, and Policy Committee for March 2nd to order. Representative Meckland, have you had a minute to look over the minutes?
I have, Madam Chair. I move to make a motion to move the minutes.
Okay, Rep. Meckland moves approval of the minutes from February 28th, 2023. Any additions or corrections? Seeing none, all those in favor of adopting the minutes say aye.
Aye.
Opposed? Motion prevails. The minutes are approved. Okay, the first bill. Actually, one moment. I'm going to exploit my minute of being the chair here. I want to welcome all of Labor sitting in the room today. Thank you so much for joining us. I see some of my favorite faces here. We really appreciate it. Okay, first bill on the agenda is HF 1522. Rep. Nelson moves that HF 1522 be re-referred to the Judiciary, Finance, and Civil Law Committee. Rep. Nelson, to your bill.
Madam Chair, that's my motion.
Go ahead and introduce yourself and present your bill.
House File 1522 is a modification or upgrade of some of the OSHA bills that we have here, Section 1 of the bill, and I'd like to invite the commissioner down here to testify and maybe help me with it. Modify some of the existing law on occupational safety and health is the first Section 1 of the bill. Protection 2 is the protections about subpoena data. Section 3 is classification of the citation data, and again, this is a bill that's from the department, so I'll let the commissioner explain the bill better.
Welcome, Commissioner. Please state your name for the record and proceed.
Thank you, Chair. Good afternoon, Chair, members of the committee. My name is Nicole Blissenbach. I am the Commissioner of the Department of Labor and Industry, and thank you for the opportunity to testify today in support of House File 1522. Before I get into the specifics of the bill, I just want to talk, this committee has heard a lot about workplace safety, and I want to reiterate that one of my priorities as commissioner is to find ways to be more effective in our enforcement of OSHA standards. But enforcement can't be the only tool that we utilize to ensure that employees make it home safe to their families at the end of the workday. In addition to strategic and effective enforcement, we need laws and standards that deter OSHA violations and promote voluntary compliance. We need clarity in our laws and standards so everyone knows their responsibilities. We need education and training so that workplace hazards can be identified and abated long before an injury occurs. And we need worker voice present in workplace safety discussions. Ultimately, achieving workplace safety requires many approaches. So with that as context, the bill before you today makes 5 policy and technical changes that support workplace safety, transparency, and smooth program operations at Minnesota OSHA. So first, the bill supports the privacy of employee interviews. Minnesota OSHA already has the authority to privately question employees as part of their authority to inspect. This change clarifies that an employer or its representatives may not be present for any employee interview. The ultimate goal of OSHA investigation is to determine the facts, what happened. These interviews often happen after a serious injury or fatality. The presence of an employer representative in an interview between an OSHA investigator and a non-management employee can have a chilling effect on the employee's ability to share information freely about the circumstances leading to a workplace injury. Protecting the privacy of these interviews and eliminating the direct presence of an employer ensures that employees can speak freely without fear of retaliation when speaking with an OSHA investigator. Second, the bill clarifies that both current and former employees are not, OSHA employees are not subject to subpoena for purposes of inquiry into occupational safety and health inspections. This is really a technical change to existing law. Third, the bill improves the transparency of Minnesota OSHA citation data. This change would classify written citation data as public 20 days after the employer has received the citation. This proposal would allow Minnesota OSHA to provide timely information to the public and stakeholders about its enforcement actions, which would encourage employers to take the necessary steps to keep their employees safe. Additionally, this legislation would align Minnesota OSHA with other OSHA programs across the United States, including all of our neighboring states. Fourth, the bill creates a process that allows for an expedited abatement when an employer contests the period of time for correction of a violation that is serious, willful, or repeat. If a matter is referred to an administrative law judge for an expedited contested case hearing on the reasonableness of the time fixed for the correction, the ALJ can order the employer to correct the violation pending the final resolution of the cited violations on the merits. So it essentially allows for abatement to happen quicker while a contested case hearing on the merits plays out, and that usually takes a bit longer. This ensures a path to have workplace safety hazards abated promptly, promoting workplace safety to the benefit of both the employee and the employer. Finally, the bill updates safety committee requirements for employers with 25 or fewer employees. To be clear, the law already requires certain employers with 25 or fewer employees to have a safety committee. This bill makes it clear to these small employers whether they fall under that requirement and whether they're required to have that safety committee. It's a simpler process for identifying which small employers are required to have safety committees, and that will ease the burden on employers. In addition, the new system of determining whether an employer needs to have a safety committee only requires one if the employer is in an industry that is already required to have a workplace accident and injury reduction program. This ensures that safety committees are required in the industries that need them most and the industries that are most prepared to implement them. Each of these changes makes an important update to Minnesota OSHA policy. These changes support the workers, the employers, and the occupational safety and health professionals whose shared goal is to move Minnesota forward as a leader in workplace safety. Thank you for the opportunity to speak in support of House File 1522, and I'm happy to answer any questions.
Thank you, Commissioner. I think we'll move on to our next testifier, Adam Dunnick.
Question.
Welcome. Please state your name for the record and proceed.
Thank you, Madam Chair, members of the House Labor Committee. My name is Adam Dunnick. I'm here on behalf of the North Central States Regional Council of Carpenters. I want to thank the department for bringing this bill forward. We have supported it in the past. We supported it 2 years ago for two simple reasons. We support it because it both brings Minnesota up to a similar standard as our surrounding states. Today, if there's an OSHA violation and citation made public, it's made public within hours, if not a day or so, in states like Wisconsin and Nebraska and the surrounding states. So this brings us up more into alignment with them. And secondly, for us, it's an issue of fairness. Right now, OSHA citations in Minnesota are made public right away if you're a union contractor or have a union member working on the site, because it's part of our collective bargaining process. So right now, the only citations not being made public are actually on non-union sites. So it's an issue of fairness. And it's a very heavy and heartfelt week for us to talk about this issue. We lost one of our members a week ago, and it was a sad time, a really hard time for our contractor, a member, and the other workers on that site out in Edina. And we just urge your support for this bill today. Thank you, Madam Chair.
Thank you, and thank you for being willing to share that with us. Sorry to hear that. Our next testifier is John Beshy. Welcome to the committee. Please state your name for the record and proceed.
Thank you, Madam Chair, and members of the committee. For the record, my name is John Beshy. You got that correct. Not everybody does. And I'm here on behalf of the Associated Builders and Contractors of Minnesota. ABC's 330 commercial and industrial contractor members and the 20,000 men and women that they employ are part of the 76% of the construction industry in Minnesota that choose to be merit shop craft professionals rather than be in a union. ABC is opposed to several provisions included within this bill. Before I go through those concerns, I would like to thank the chief author for meeting with us yesterday to hear about those concerns. Our first concern is that Section 1 of the bill as written would take away the right of an employee to request that an employer or the employer's attorney be present when interviewed by OSHA investigators. In practice, there are situations in which an employee may want the employer or the employer's attorney to be present during the interview, and ABC is concerned that this prohibition could violate the employee's rights to do that. For example, not too long ago, MNOSHA showed up for a routine inspection at an ABC contractor's job site and conducted employee interviews. After the fact, some of the employees informed the contractor that the MNOSHA investigator was questioning them about whether they had ever thought about joining a union. Not only is this out of the purview of MNOSHA, but it's also an example of a situation in which an employee may want to reserve that right to have the employer present. The bottom line on Section 1 for us is that employees, not the legislature, should be the ones making the determination regarding who they want to be in the room with them during an interview. We are also opposed to the language in Section 3 of the bill, which is related to the classification of MNOSHA citation data. Current law and practice already make MNOSHA citation records timely and readily available through federal OSHA's public website after the matter is closed by the department. Anyone can search this website for citations listed by the employer, project zip code, date range, and more. We're concerned that the publication of the nature of the investigation before claims are fully adjudicated will create an appearance of guilty until proven innocent for the named contractor. There are many times when a citation is issued and a contractor appeals that citation. When that happens and the contractor is successful, the penalty or the fine may be reduced or not levied at all. ABC members have been subject to dozens of OSHA investigations based on anonymous complaints that were later determined to be without merit. However, the appeals process can take some time. If this section is enacted, we are concerned that the publicly available information could be used to engage in smear campaigns against contractors, even if the allegations in the citation haven't been formally adjudicated or even subsequently dropped by the department. The publication of this data has been compared to the publication of criminal charges, which let the public know of the alleged offense. However, in criminal cases, the burden of proof is on the government, and those charged with the crime are innocent until proven guilty. The government must also produce its evidence and make its case in a criminal matter. In contrast, in a MNOSHA citation matter, the individual is essentially guilty until proven innocent, and MNOSHA does not have to produce its original records with the evidence of the violation until after the notice of contest is filed. This makes it extremely difficult for employers to determine whether the complaints against them have merit and to adequately respond to allegations. Finally, if these details are made public 20 days after the employer receives the citation, we think that MNOSHA should also be required to provide the accused with copies of any documents that detail the evidence of the violation upon issuance of the citation. In closing, we respectfully urge the committee to vote no on House File 1522. Thank you again, Madam Chair and members of the committee, for the opportunity to testify. And I'm happy to take any questions too.
Thank you very much for your testimony. Further discussion on the bill? Representative Meyer.
Thank you, Chair Berg. You know, I've heard two people testify, and I guess I have a question for the bill author in regards to that citation piece. You know, I heard a bill in a different committee. Again, it was not this one, it was in housing, where they talked about the presumption of having an eviction on your record right away has, you know, detrimental effect to an individual. And now I'm just seeing in this one, as far as an employer, we're putting it where it's going to be public within 20 days. I'm just trying to figure out a little bit more of the reasoning and, you know, what you had talked about what other states were doing. It just seemed a little bit conflicting.
Chair Nelson.
Madam Chair and Representative Myers, my understandings, and as it was testified, this is what happens in other states, but currently in union contract sites, that happens right away. The OSHA citation is posted right away, where non-union sites that is not. So this is bringing fairness to both sides of the construction industry.
Representative Meyer.
Yep. Thank you for that clarification. I was just trying to, you know, make sure, because I think we all know when, you know, you don't have a chance to dispute something, things can come up that are truthful, not truthful, partially truthful. So I appreciate you answering that.
Lead McDonald.
Thank you, Chair Berg. Representative Nelson, I'm not necessarily against your bill. I think it's a very important bill and certainly needed for good governance. The concern that I have is that the the citation will be made public before the employer even has a chance to defend himself. So once he is adjudicated of any wrongdoing, say there is a mistake in the claim, then it's already made public with all the information. And I think that's to be concerned, wouldn't you say?
Chair Nelson.
Madam Chair, Representative McDonald, as I stated, it's already the case for union contractors that they have to do that because it's in their bargaining agreements. This is just making a fairness on both sides of whether you're union or non-union, that those are published so that people know.
Lead McDonald.
Thank you, Chair. Well, then that's not fair for the unions either. I mean, if there's a claim, let's say you're an employer, and there's a claim that there was unsafe practice or some kind of mistake, and then it's made public, everybody knows about it, it's in the newspapers, it's on the news if it's a high-profile case, and then weeks down the road, maybe a month, it's adjudicated and there was no mistake, it was a wrongful citation, the damage has been done already, so I don't think it's fair for private contractors or unions completely. I think that particular law at least should be amended, that before it's made public, that all the information is granted and given before there's a citation and or public information. So that's just my thought. I think it's only in fairness for the employer. And if there is an egregious mistake and there's been mistakes or unsafe practices, then certainly that should be made public when at the time that it's judged that that was appropriate. Don't you think that would be a fair statement as well, Representative Nelson?
Chair
Madam
Nelson.
Chair and Representative McDonald, as it was stated in the testimony, this is the way it happens in Wisconsin, this is the way it happens around other states, and this is the way, this is to bring fairness and bring us in line with the other states around us and the way that it's handled.
Follow up, Lead
Yes,
McDonald.
thank you, Madam Chair. Well, for the record, now, do you really want to be compared to Wisconsin? Not that there's anything wrong with Wisconsin, but we are Minnesota. We're supposed to be above them. That's all I have to say, Madam Chair.
Further discussion? Rep. Nelson, or pardon me, Chair Nelson, any final comments?
Madam Chair, this is, like I said, this is just an update of our OSHA standards. And with that, Madam Chair, I'll renew my motion that House File 1522 be re-referred to the Judiciary, Finance, and Civil Law Committee.
Chair Nelson renews his motion that House File 1522 be re-referred to the Judiciary, Finance, and Civil Law Committee. All those in favor say aye.
Aye.
Opposed? Motion carries and the bill is on its way.
Madam Chair, we'll take Representative Feist, start Representative Feist's bill. She's not, start getting testimony.
Is this a good time for a Wisconsin joke?
I'll move House File
What's the best way to view?
1522 to be referred to the Judiciary Committee?
Yeah, I would.
1859. Read the right number there. Myself here. And with that, we'll start taking testimony on the bill. And the first person on the list I have is Adam Dunnick. Again, welcome back to the committee, and if you want to give your testimony, state your name for the record.
Thank you, Mr. Chair, members of the House Labor Committee. My name is Adam Dunnick. I'm the director.
Mr. Chair?
Yeah, the author's not here, Mr. Chair, if that's of concern.
Sure. Which bill are we on, Mr. Chair?
We're on House File 1859, Representative Feist bill, and this, we've got a lot of testifiers, so we're going to start doing the testifiers while before she gets here. She's in another committee.
Mr. Chair, is there any co-author of the bill who could potentially speak at least to the initial points of the bill, just for introduction's sake?
Representative Berg is a co-author of the bill.
And Mr. Chair?
But like I said, we'll start with the testimony, so we can, because we have a lot of testifiers, so we can get.
And I fully agree with you, Mr. Chair. I would just like, just literally the opening introduction to the bill that we're discussing.
Representative Feist, or Representative Berg, you can do it from there.
Mr. Chair,
Representative Jordan.
thank you, Mr. Chair. Could maybe nonpartisan staff like walk through the bill?
We could have one part, yeah, one nonpartisan staff. Why don't you walk through the bill?
Chair and members, sorry, I don't have my tent out. Mary Davis from
Yep.
Pulse Research. This is a bill that creates some wage protection laws for construction workers. Some of them are similar to other employee labor protections that exist, and then some of them are a new section. They create a private lawsuit when construction workers are not paid by subcontractors or contractors for work on construction projects. And then there are some exemptions for construction projects. They're usually larger construction projects, not like somebody coming into your home to work on a single-family home or a duplex, but usually larger than that. And that's kind of the overview of the bill. But if you are familiar with other wage protection laws, being able to sue your employer for wages that you're owed, that's the gist of the bill.
Mr. Dunick, if you want to state your name for the record and proceed with your testimony. The next person I have on my list after that is Simon Troutman. So Representative, and just so you're ready to go.
Thank you, Chair Nelson and members of the House Labor Committee. Again, I'm Adam Dunick with the North Central States Regional Council of Carpenters. It's a pleasure to be with you today, and I want to say a warm thank you to Representative Feist for carrying this bill for us. I can't wait to hear what she has to say about it as well. In summary, the House File 1859.
Excuse me, Mr. Chair.
Representative McDonald.
Sorry to interrupt you, Mr. Dunick, but don't we have to move the bill first before testimony, or?
I moved the bill.
You did already,
I moved
okay.
the bill to be referred to civil law, judiciary, and finance and civil law.
Okay, my apologies. In the confusion, I did not hear that part.
It's, yes. Representative, Mr. Dunick.
Thank you, Mr. Chair and committee members. In summary, House File 1859 will ensure that construction workers subjected to wage theft have recourse to collect unpaid wages from contractors. General contractors and project owners will see the necessity to hire responsible subcontractors by placing the responsibility to prevent wage theft upon those with the most control over their construction projects. Compliance would finally be incentivized. Before I begin about the specifics of the bill, I want to talk about how unequivocally we are opposed to wage theft in the construction industry. It's bad for workers, it's bad for law-abiding businesses, and it's bad for the community. We believe that general contractors subcontract parts of their job but should remain responsible for the labor subcontracted. Today, general contractors are responsible for safety on their project, and they can be held accountable for that. They're responsible for workers' compensation on their job sites too, and they can be held accountable for that. We are asking that wage and hour violations also be the responsibility of general contractors. For years, we heard from generals and developers that this sort of misclassification has created an unlevel playing field for them as a business. For years, we were also asked by AGC and other employer partners what we are doing on behalf of workers being paid off the books. Some may ask, why are we back talking about this legislation when a great wage theft bill was passed in 2019? The biggest reason is that we haven't seen much change in our industry since then. Approximately half of the multifamily work that's gone on in the Twin Cities and around the state in wood frame, drywall, and other scopes of work are still being performed by subcontractors paying cash under the table. In some ways, it took a high-profile case of alleged wage theft for us to consider this legislation. And the workers that we assisted at Viking Lakes and Egan and across other projects in the Twin Cities were owed thousands of dollars over not just months, but sometimes years. But it's not just about one general contractor or one project. It's about the entire system. And unfortunately, there are many who are breaking the rules and benefiting from the status quo. And who loses? It's the workers. And imagine being one of those exploited workers. And you're going to be able to hear some testimony from some of those workers today. Being owed large sums of money and having no ability to seek recourse from your employer. We think of this bill as leveling the playing field between the worker and their employer, because right now they're being told, go seek recourse from your direct employer, when there's multiple tiers of contractors that are intentionally set up to make it confusing. We continue to meet with the agency because it is important for us to maintain a partnership with them. However, if they're not going to push for the sort of changes that workers deserve, we're going to continue to push for these changes to help us deter and eliminate wage theft once and for all. Any amount of worker exploitation is too much, and it must not go unchecked. We believe that the best enforcement on wage theft and paying workers off the book is compliance. And the best way to ensure that is that general contractors are held liable for all the workers on their site. Our goal is not for a bunch of contractors to be caught breaking the law. Our goal is for general contractors to do the right thing. Hire subcontractors who have real payrolls. Hire subcontractors who have employees that are paid on the books, not cutting corners. This practice must stop, and we believe that this bill will finally help make meaningful change. Thank you, Mr. Chair.
Thank you, Mr. Dunning. Simon Troutman?
Thank you, Chair. My name is Simon Troutman. Oh,
Got the author. No, you're good.
Representative Feist, we've moved your bill, and we're currently going through testimony.
Excellent. Thank you so much. I apologize for being late.
The amendment.
Should I say things?
Representative Feist, if you catch your breath here.
Okay.
If you want to just briefly explain the bill, we had nonpartisan staff walk through it, and there is an amendment, but I understand that the amendment came in late, and we're just going to talk about it and not put it on in this committee.
Yes, Mr. Chair, that's correct.
Representative Feist.
Great. Thank you so much. Hello, committee. I apologize for being late. I was presenting another bill in another committee.
And Representative Feist, that's something that happens this time of year all the time. So, Representative Feist.
Well, thank you. So just to the amendment briefly, that was the result of conversations to expand the exemption around collective bargaining agreements. And we did not submit it in time for this committee, but we wanted to make sure that the committee saw it, just to know that conversations are ongoing, to make sure that this bill has the effect intended. And we are in a lot of conversations. We appreciate those conversations. So this bill is to address wage theft. Wage theft is so common in construction that labor experts say that it amounts to a business model. 1 in 5 workers in Minnesota is likely to experience being misclassified, paid off the books, or have their wages stolen. These workers often don't even know who they're working for. 2019 law that we passed has been a positive step forward, but this issue remains prevalent. The wage theft impacts approximately 23% of construction workers. This is a business model that's been set up for the purposes of profiting from the exploitation of largely immigrant construction workforce. This is a really important issue that we're trying to address. It's found on about 50% of multifamily construction projects under the drywall, wood, framing, painting, roofing, and siding scopes of work. It's rarely found on projects covered by prevailing wage laws or on union projects, which is why we have that exemption for collective bargaining agreements, which we're looking at expanding, because those workers have recourse on those projects to ensure that they are paid properly. This bill provides that recourse to these workers who have been victimized by wage theft. Contractors engaging in the subcontracting of labor on their construction projects will be liable for the unpaid wages and damages stemming therefrom of the subcontractors performing work that is under their control. This bill applies to construction contractors and project owners if they are hiring multiple contractors who subcontract construction labor under their control. This will ensure that the construction workers subjected to wage theft have recourse to collect unpaid wages from contractors and to incentivize hiring of responsible contractors by placing the responsibility to prevent wage theft upon those with the most control over construction labor practices. 8 other states have passed similar laws to the one that is before you today. And the bottom line is that if you control the worksite, then you can prevent wage theft. If you have access to the information on reputations and past actions of the possible subcontractors, you have control over wage theft. A subcontractor committing wage theft will have a bid about 30% lower than a legitimate subcontractor's bid would be. So you can see by the bid itself if you might have a wage theft problem. You can choose to subcontract for skills that, as a construction manager, you could hire and supervise directly. So you're making a choice to subcontract with a subcontractor. This bill provides more tools to enable general contractors to prevent that wage theft by requiring the contractors are entitled to a variety of information. And this bill levels the playing field between those that do care and have very ethical business practices. And I've talked with a lot of folks who work with general contractors who do have ethical business practices, who work with those general contractors. And we want to level the playing field so that the ethical business practices can win the day, and they're not going to be underbid by unethical subcontractors. And this bill is also designed to avoid unintended collateral consequences. Again, it has been passed in numerous other states. And I just want to highlight that there are significant exemptions, which we are working on to expand, including single-family and two-family dwellings, home remodels. So if I hire contractors, I'm not going to be subject to this as a homeowner. And again, prevailing wage projects where there is already recourse in place for workers, and collective bargaining agreements where we're expanding that exemption. Investigative resources are so scarce that even bad actors right now are not getting caught. So this concern that there's just going to be these floodgates and all of this, investigation of, people, general contractors and project managers who are doing the right thing, we do not expect that to happen. There haven't been investigations of even really bad, egregious examples of wage theft. And I could say a lot of other stuff, but I guess I'll just close by saying that I appreciate all the conversations I've had with folks who have concerns about this bill. And I am committed to continuing those conversations because I think that's what we do for good governance. And so I look forward to the conversation today, and I'll leave it to the experts and the workers at this point.
Thank you, Representative Feist. And again, Mr. Troutman, go ahead and identify yourself for the record and proceed.
Thank you so much, Chairman, and thank you so much for having us here today. My name is Simon Troutman. I'm a Richfield City Council member. I'm also an attorney that fights wage theft and also represents contractors. And I'm the chair of an organization called City Leaders Against Wage Theft and Tax Fraud. And we're here today. We represent more than 20 local municipal leaders who believe and are committed to the proposition that wage theft is some of the worst theft that takes place in Minnesota or anywhere, where you take money from working people after they've traded the only thing that they have in the world oftentimes. We know in Minnesota, more than 1 in 2 Minnesotans would struggle to make a payment of $500 in an emergency if they had that. And there's no time where someone is more vulnerable than when they've traded their labor for a promise to be paid. And in the situation where we have wage theft, where we have, and I appreciate the comment that this is a business model. We have a situation, a policy position where ignorance from the contractor is incentivized and theft is rewarded. And the only thing I would add to Mr. Dunnick's testimony is that in addition to the workers, and you're going to hear powerful stories from workers who've had their wages stolen, but also good faith actors that are losing out on great contracts, but also the government. We have a bipartisan group of people who don't like taxes being stolen from the government. So we miss those opportunities. And in the wake of that, we have an inability of people who've had their wages stolen to be held accountable. For those that aren't familiar with the practice, you'll have a subcontractor that has an LLC with 0 assets. And so that creates an opportunity, a policy problem, where there is literally no money. There's literally nobody accountable. And the person who's most accountable, who's in the best position to be able to make sure that the laws are complied, that taxes are paid, and that workers who've worked get paid is the general contractor. So what we're asking is that you would earnestly consider the consequences in your districts, on your block, if on your block 3 or 4 out of 20 of the homes on your block had been broken into and stolen. If 1 in 2 Americans can't pay a $500 bill, and 1 in 5 of those Minnesotans in the trades have been the victim of wage theft, we're asking for the tool to hold them accountable. As a lawyer, we need this tool. As a council member, we need this tool. And for all the workers who are here, we earnestly ask you for this opportunity to be paid for the wages they've worked for. This is a sacred trust, and we're grateful. Thank you so much.
Thank you, Mr. Troutman. The next person on my list is Flavio Marino, and I know I probably butchered that name. Welcome to the committee. Again, state your name for the record and proceed with your testimony.
Presidente representante Michelle Nelson. Gracias, señor presidente y miembro del comité de la Cámara. Mi nombre es Ángel Polivio Merino.
All right, and my name is Diana Solorzano. I am representing Mr. Polivio to help him interpret his testimony. Thank you, Mr. Chairman and House Committee members. My name is Ángel Polivio.
Trabajo en la construcción. Estoy aquí para apoyar el archivo 1859 de la Cámara.
I work in construction. I'm here in support of House File 1859.
Esto requeriría que los contratistas y desarrolladores sean responsables de las acciones de los subcontratistas que contratan en sus lugares de trabajo.
This would require contractors and developers to be responsible for the actions of the subcontractors they hire on their job sites.
Los contratistas ya no podrían ignorar la clasificación errónea y el robo de salarios en estos lugares de trabajo. Deben estar y estarán obligados a contratar empresas que utilicen sistemas de nómina legítimos para pagar a sus trabajadores o ser considerados responsables.
No longer would contractors be able to ignore the misclassification and wage theft on these job sites. They should be and will be obligated to hire companies who use legitimate payroll systems to pay their workers or be held responsible.
Finalmente, los trabajadores duros como yo no serían explotados por compañías que operan usando un modelo de negocio de robo de salarios.
Finally, hard workers like myself would not be exploited by companies operating using a wage theft business model.
Hace aproximadamente 2 años que yo trabajé en un proyecto que se llama Pastor Apartment.
Approximately 2 years ago, I worked at a project for pastors' apartments,
en el cual me ofrecieron un precio a pagar que yo estaría como encargado y conseguiría más gente para trabajar en él.
that for a specific payment, I would be in charge and would need to hire workers for this project.
Y siempre que yo estaba encargado y conseguía más gente, siempre me exigían más y más, pero el salario nunca me lo aumentaron.
Whenever I was in charge of hiring more and more people for this project and getting more responsibilities, but never received any increase in payments.
En lo cual que me ofrecieron un precio y me llegaron pagando a 75 centavos el pie cuadrado.
In which they told me a specific amount, but ended up paying me 75 cents per square foot.
Y pues me hicieron que yo les agarrara unos cheques para que yo pueda pagar a los compañeros que traía yo de trabajo.
They made me cash in some checks so I could pay the workers that I had brought in,
En el cual yo no era el contratista.
in which I was not the subcontractor.
Luego de eso, pues no nos pagaron todo y luego de eso me fui de este trabajo también a hacer unas casas que también no me pagaron.
After that, I wasn't paid for the work that I did, so I took work somewhere else to help build some houses where I also wasn't paid for this work.
Entonces, pues les quería pedir que si podemos o nos pueden ayudar en esto, terminar con esta pandemia.
So that's why I'm here today, to ask you for help so you could help end this pandemic.
Bajo esta legislación, la empresa que contrató a este intermediario laboral y dueño de Yellow Tree sería responsable, ya que nos pagaban en efectivo y nunca hubo una nómina. Podrían haber requerido a Yellow Tree.
Under this legislation, the company that hired this labor broker and owner of Yellow Tree would be responsible, since we were paid in cash and there was never any payroll.
En mi caso, para proporcionar pruebas de nómina y fácilmente se habrían enterado de que estábamos siendo victimizados.
They could have required Yellow Tree, in my case, to provide proof of payroll, and they would have easily learned that we were being victimized.
Esto podría proporcionar responsabilidad directa sin hacer más la vista gorda y los trabajadores como yo en todo Minnesota podrían cobrar parte de sus salarios impagos.
This could provide direct liability, no more turning a blind eye, and workers just like me all over Minnesota would be able to collect some of their unpaid wages.
Es un paso en la dirección de tratar a los trabajadores con dignidad y respeto.
This is a step in the right direction, treating workers with dignity and respect.
Muchas gracias, señor presidente y miembros, por su tiempo.
Thank you, Mr. Chairman and members for your time.
Thank you, sir. Octavio Chung is the next person. And then after that, then if you get ready, is Alvarez Chavez. Welcome to the committee. Please state your name for the record and proceed with your testimony.
Chair Nelson and committee members, for the record, my name is Octavio Chung Bustamante. I'm an organizer for the Labor's Union, La Una. I'm originally from Panama, and my wife is from Minnesota, and we now live in Hugo. When I came here, I had to review my entire life. Other than my wife, I did not know anyone I could not speak well. As you can't, but like many Latino immigrants, I found work in the construction industry, but I was lucky. My employer paid family supporting wages and provide union health, retirement, and training benefits. Equally important, they pay their taxes, unemployment, and workers' compensation premium. If I was laid off because of work was slow, I had unemployment insurance to get me and my family through. If I or one of my coworkers got hurt on that job, we receive proper medical care. Sadly, many workers are not so lucky. Part of my job as an organizer with La Una is to prevent irresponsible contractors from getting ahead by cheating workers and taxpayers and undercutting law-obedient competitors by breaking the law through tax and insurance fraud. Here is an example. Last year, I assisted a worker named Marco who had recently broken his ankle after filing of a letter in a construction project. The general contractor of the project was a subsidiary of a multi-billion-dollar building supply company. When Marco was injured, his direct boss, a so-called independent contractor, should have arranged medical treatment for him and helped him file a workers' compensation claim. Instead, Marco and a coworker explained to me that their boss tried to persuade Marco to lie to authorities and seek medical care under the boss's name at taxpayer expense. Marco said that when he refused to participate in the scheme, the boss responded by firing him and his coworker and by threatening to report them to the police and immigration enforcement. Marco's injury prevented him from working in construction, and he faced thousands of dollars in medical debt, while the lawyers argue over who should pay the bills. This is not how the system is supposed to work, but I can tell you, based on my experience, stories like Marco are far too common. The nightmare that workers like Marco face on a daily basis won't end until we start holding general contractors responsible for abuses that happen on their watch. Under current law, general contractors like the one that hired Marco's boss don't face any real consequences for using subcontractors that exploit workers and cheat taxpayers. We have shared evidence of wage theft and other abuses with general contractors on many occasions, but our pleas have largely been ignored because they clearly don't seem as it is their problem. House File 1859 will level the playing field for responsible contractors and ensure contractors that enrich themselves at the expense of workers and taxpayers are held accountable. I ask you all to support this proposal. Thank you to Representative Feist for introducing a bill that will better serve and protect construction workers who often don't know their rights or where to turn for help. And finally, Chair Nelson, I want to remind members of the committee that this issue affects real people. The workers that are building our remarkable communities in every corner of the state of Minnesota. Thank you.
Thank you, sir, for your testimony. Alvarez Chavez. And then the next person on my list is Dan McConnell. So if you can be ready. Welcome to the committee and state your name for the record. And then proceed with your testimony.
Okay. Mi nombre es Álvaro Chávez.
And I'm assuming you're.
My name is Alvaro Chavez. My name is Carlos Garcia Velasco. I'm here to interpret and a lead organizer with the Workers Center.
That's what I assumed, yes.
Thank you.
Go ahead, Mr. Chavez.
Mi nombre es Álvaro Chávez. Vivo en St. Paul con mi novia. He trabajado en la industria de la construcción desde hace 4 años. Conozco los problemas de la industria hace 17 años por la experiencia de mi papá, quien ha sufrido todos estos años las situaciones de abusos al trabajador, incluyendo robo de salario. Desde que empecé, he sufrido el robo de salario, maltratos verbales y pagos injustos para los riesgos y esfuerzos que hacemos. En mi caso y el de mi padre, nunca hemos recibido un pago por tiempo extra y nos ha pasado accidentes sin recibir una compensación laboral. No recibimos ningún beneficio porque éramos clasificados como contratistas independientes. Me siento enojado viendo que mi papá sufre tanto y un día le dije a mi papá que buscara en otro lugar un trato justo y un mejor pago mientras yo seguía en este grupo para pagar nuestros gastos. He trabajado con diferentes grupos y siempre es la misma historia. En julio de 2021 empezamos un edificio multifamiliar, un proyecto aquí en University Avenue, en St. Paul, en que Yellow Tree fue el contratista general. Trabajábamos jornadas de 10 a 11 horas y nunca recibimos un pago por trabajo de tiempo extra. Fue un trabajo muy pesado y me lastimé la espalda. Otro compañero también tuvo un accidente en el trabajo. Como no teníamos los beneficios médicos que un trabajador debe tener y tampoco ganábamos lo suficiente para pagar por nuestras cuentas los cuidados médicos, nunca se trataron nuestras lesiones. Nos forzaron a hacer lo más difícil del trabajo en el primer piso del edificio, con la promesa de que íbamos a hacer todo el proyecto. Pero cuando estábamos terminando la planta baja, nos sacaron del proyecto y pusieron a otro grupo a hacer lo que nosotros estábamos haciendo. Nos sacaron sin pagar por el trabajo hecho. Cuando el encargado del grupo llamó al dueño de la compañía, Strong Fryman, un subcontratista, en este proyecto no contestó el teléfono para evitar el pago. Buscamos ayuda en la Unión de Carpinteros y así conocimos a DECETUR. Se inició el proceso de reclamo, pero no sabíamos a quién era responsable de pagarnos, ya que la persona que nos contrató no contestaba el teléfono. Tomamos la decisión de llamar a Yellow Tree y nos dijeron que ellos habían contratado a Just Fryman para hacer el trabajo, que le llamaran a ellos. Just Fryman dijo que ellos contrataron a Strong Fryman, la compañía de la persona que no nos contestaba. Ninguna de estas compañías querían tomar responsabilidad para pagar nuestros sueldos. Esta es una historia muy común en la industria de la construcción. Por eso mi papá y mi hermana me motivan a actuar y levantar mi voz para dar a conocer las injusticias que sufrimos. Nosotros trabajamos para suplir necesidades de nuestras familias. Somos los que hacemos el trabajo duro y para cumplir en los proyectos, exclusive arriesgando nuestra salud. Parece que los contratistas generales como Yellow Tree no quieren pensar en las problemáticas que pasa con los trabajadores. Parece que están preocupados solamente por su dinero. Aprobar esta ley marcaría la diferencia para los trabajadores como yo, que estamos enfrentando el robo de salario frecuentemente. La ley de robo de salario de 2019 fue un paso importante, pero también necesitamos una ley más enfocada en las necesidades de la industria de construcción, que nos garanticen que los contratistas generales se responsabilicen y garanticen tratos y pagos justos a los que hacemos el trabajo difícil y duro, Gracias por la oportunidad de darnos a conocer mi historia y la ley y de muchos que por miedo de represalias no se atreven a denunciar las violaciones de sus derechos. Les urge apoyar esta ley.
My name is Alvaro Chavez. My girlfriend and I live in St. Paul. I have worked in construction for 4 years. I have also seen the problems that exist for workers in the industry through the experience of my father, who has suffered many abuses for the last 17 years, including wage theft. Since I started working in construction, I have experienced wage theft, verbal abuse, and pay that isn't sufficient for the hard and dangerous work that we do. In my case, and in my father's, we have never received overtime pay, and we have had accidents at work but didn't receive workers' compensation. We haven't received those benefits because we were misclassified as independent contractors. I felt angry seeing my father suffer so much, and I told him to look for other work where he is treated better and has better pay, and I continued working in construction to make sure we could pay our bills. I have worked with various different crews, and it's always the same story. In July of 2021, we began to work on a multifamily project on University Avenue here in St. Paul, where Yellow Tree was the general contractor. We worked 10 to 11-hour days, and we never received overtime pay. It was really difficult work and caused me to injure my back. Another coworker also had an accident on the project. Because we didn't have workers' compensation insurance or other benefits, and we didn't also make enough to pay for our own medical bills, we were never able to get our injuries treated. We were forced to do the most difficult work on the first floor of the building with the promise that we would be able to work on the rest of the project as well. But when we finished the lower floor, they took us off the project and hired a different group to do the work we had been doing. They never paid us for the work we had already done. When the supervisor for our group called the owner of the company, Strong Framing, who was a subcontractor on this project, he wouldn't answer the phone. We contacted the Carpenters Union for help, and that's how we were connected with SATUL, a worker center. We began the process of filing a wage complaint, and we didn't know who was responsible for paying us since the person who had contracted us wasn't answering the phone. We made the decision to call Yellow Tree, and they told us they had contracted with U.S. Framing to do the work, and we should call them. When we called U.S. Framing, they told us they contracted with Strong Framing, the company of the person who was no longer answering our calls. None of these companies wanted to take responsibility for paying our wages. This is a very common story in the construction industry. And this is why my father, my sister, and I were motivated to act and to speak out about the injustices that are happening. We work to be able to take care of our families. We are the ones who do the hard work to complete those projects, sometimes risking our health. It seems that general contractors such as Yellow Tree don't want to have to think about violations of workers' rights that may occur on their projects. It seems that they are only concerned with their financial investments. Passing this law would make a big difference for workers like me who are frequently dealing with wage theft. The wage theft law of 2019 was an important step, but we also need a law focused on the needs and problems in the construction industry, one that guarantees that general contractors will take responsibility and guarantee that we are paid what we are owed for doing the hard work. Thank you for the opportunity to tell my story and the story of many other workers that haven't come forward yet for fear of retaliation. We urge you to support and pass this bill. Thank you.
Thank you. Mr. Dan McConnell, the next I have Tim Workey, and if we can limit it to 2 to 3 minutes, it would be great because we got a few more testifiers and we needed to have discussion of this bill. Welcome to the committee. State your name for the record.
Good afternoon, Chair Nelson, members of the committee. My name is Dan McConnell. I'm the president of the Minnesota Building and Construction Trades Council, and I'm here on behalf of the 70,000 members who live in every corner of our state. It's a privilege for me to be here and to testify on this bill. On behalf of the building trades, I'm here to speak in favor of House File 1859 because wage theft has been and continues to be a serious problem in the construction industry. Every day, general contractors make decisions about who does different scopes of work for them on their projects. They decide what they perform and what they subcontract out. They make decisions and are held accountable for many of those decisions, from safety to workers' comp to schedule and who is paid on their project. Managing the project and making sure everyone is paid is literally what owners pay a general contractor to do. Even though we passed a wage theft bill in Minnesota in 2019, nobody who works in this industry can honestly say that the problem is solved. It's going to take all of us to solve this problem: federal, state, local decision makers, construction trades unions, and our contractor partners. We have a track record of working with our contractors collaboratively. For example, we work together on employee benefit programs, our joint apprenticeship training programs, recruiting workers, and on advocating for jobs for our members. Now we need our general contracting partners to continue to step up on this issue of workers being paid cash under the table. It's unlawful, it's worse, and it's morally wrong. Most of the general contractors we work with do the right thing, but as often is the case, it only takes a few bad apples to ruin it for everyone. When competing for jobs, contracts are awarded to the lowest bidder. The incentive to engage in unscrupulous behavior or to simply look the other way can mean the difference between getting the next job or losing it to a competitor who is willing to do it, the unlawful acts, and then potentially going out of business yourself. We're glad to hear the AGC has called for more government oversight and for funding for enforcement of existing laws. We agree with that call, but are skeptical that there will ever be enough external eyes to watch every project throughout our state. This bill will empower every worker to be part of the solution to this problem. Doing nothing is not an option when so many workers are being hurt, mistreated, and taken advantage of. It's going to take everyone working together, and I ask the Labor Committee and the House to pass this Construction Worker Wage Protection Act to empower workers who have been victims to hold their bad actors accountable. Thank you for the opportunity to speak with you today.
Thank you, Mr. McConnell. Mr. Werke, the next person I have on is Wendy Sullivan. Welcome to the committee. State your name for the record.
Yes, sir. Good afternoon, Mr. Chair, committee members. Thank you for the opportunity to testify. My name is Tim Werke. I'm the Chief Executive Officer of the Associated General Contractors of Minnesota. We represent over 350 commercial general contractors, subcontractors, and suppliers. We are 80% of our members are union signatory contractors, and we perform strictly commercial construction work, no residential. Mr. Chair, some key points with respect to this bill. Let me first begin by saying no one in our membership condones wage theft, period. Our position on this bill is that the legislation as currently written is misguided, provides an unworkable construct, and places heavy burdens on general contractors only with significant market consequences. We believe further that efforts to curb wage theft are best focused on building out the 2019 wage theft law by fully funding it and, in so doing, honoring the $3 million request for additional investigative staff that the Department of Labor and Industry has in their current budget. Over the past 6 to 8 years, there have been several major wage theft initiatives passed by this legislature, each promising an end to wage theft, and we have participated actively in the development of those laws. We do not need more legislation. What we need is a greater commitment and greater funding to help us work to make sure that those existing laws are effective. Further, you've heard that similar legislation to what is in front of you today is passed in several other states. We have yet to see any tangible evidence that those efforts with that legislation have been successful in curbing wage theft. To the bill, Mr. Chair, I want to address a very serious principle and serious provision in the bill for our members, and that is the principle of basic fairness in the imposition of what is called strict liability that this bill brings to bear. The bill shifts legal responsibility for the criminal actions of downstream contracting partners onto the upstream general contractor, regardless of the general contractor's fault or negligence. In spite of what you heard, on large-scale projects, general contractors do not control the hiring of downstream sub and further sub-tier subcontractors. They further lack complicity or responsibility for the negligent or criminal actions of those subs. The application of strict liability in this respect is unprecedented and something our members will not support. At its core, construction and contracting is about managing and pricing risk. Insurance is an important aspect of managing that risk. Mr. Chair and committee members, no insurance product exists today that will cover strict liability imposed on general contractors if this bill passes, because you cannot insure the negligence and criminal actions of another party. In this case, the downstream subcontractors. General contractors will be left to price that uninsurable risk into their projects. This will certainly lead to significant cost increases for construction services. Secondly, we're concerned about equity in public and in private construction in building out a robust women and minority construction community. Should this bill pass, it will be far likely for generals to take on unknown risks by hiring unfamiliar project partners on their project team. General contractors will be forced to demand payment bonds from unfamiliar partners to protect themselves against the risks of wage theft. Obviously, this demand will limit the capacity of women and minority and small businesses because they are the ones that will be challenged to afford the premium, and they will not be able to qualify for these types of security instruments. Our final concern, Mr. Chair, with this bill is the administrative burden that it'll impose on upstream general contractors to be responsible for collecting and managing and retaining the amounts of information that will be required. Significant unaddressed questions remain. For example, what if you have a late, non-compliant, or non-responsive project partner? Leverage in the bill provides the general contractor to withhold payment. We can only imagine what kind of disputes may arise when those payments are withheld for lack of information. Finally, there is no discernible method or mechanism in the bill to alert an upstream general contractor that a downstream sub has defaulted or has failed to make payment. In sum, the general contractor will be held liable. Mr. Chair, in the interest of time, I will reserve my former comments and say we are opposed to this bill until these significant concerns that I've briefly outlined for you today can be addressed to our satisfaction, and I'd be happy to stand for any questions.
Thank you, Mr. Werke, and Wendy Sullivan is the next person on my list. And again, if you can keep it to 2 to 3 minutes so we can get through the rest of the testifiers. Welcome to the committee. State your name for the record.
Good afternoon. My name is Wendy Sullivan. I appreciate the opportunity to speak. I am the owner of Winrich PD Construction. I am a subcontractor. I am woman-owned and minority-owned. I am the sole owner and certified as such. And I heard about this bill, and I was concerned because I've had so many obstacles in the last 9 years to break into construction, and especially into highway heavy. There are so many barriers that are existing for a small business to try to enter in when a GC or a prime is, used to working with their same partners. And in understanding this bill, it seems as if this will create another one. I think Tim Werke talked about it a little bit before me, but if I have to get a bond at that point, I'm not large enough or established enough to do that. And so that cuts me out, and along with a lot of other minority subcontractors, to participate in projects, regardless if they have goals. If we aren't able to meet those things that are within that, the parameters of getting a bond, they can say that the general contractor can say that they put in good faith effort, but we weren't able to meet those, surpass those barriers. And so I learned just yesterday, that about the bill that was put forth or passed in 2019. And that bill sounded like it got stifled a little bit with actually implementing it someone mentioned that there were 0 claims on it. And if no one's reporting anything, how do you know if that process works or not? If no one's reported any of these incidents to I think it's the Department of Labor and Industry, how do we know that bill doesn't work and it hasn't gone forward enough, it hasn't had enough time? And I said it was stifled because of COVID. And I just learned that yesterday. But the other thing I just want to say is that as I feel responsible for my business and any mistakes that I made and anything that I have to do, I don't hold the general contractor responsible for my business. I have to own that. I do own it, but I have to own it, and I have to take responsibility for that no matter how tough that is. And I guess what I'm here to say is if you could consider a small business when you're making, and minority businesses and women-owned businesses when you're making these decisions, I think the worker is so important. I work 72 hours myself a week trying to keep my business afloat. And I just think sometimes these bills, we're looking at one thing, just the worker, but the balance of that is the small subcontractor who's trying to make it in this industry. And I just ask that you guys consider this, maybe working with the legislation you have now to work through that and see if that works before going into something else that's going to harm small businesses who are trying to break into and emerge into construction. And it's tough. It's really tough to break through those barriers. And this creates another one for us. I thank you for your time, and I appreciate you letting me speak.
Thank you. Thank you for your testimony. Stephen Yoke. And then the next person I have is Bill Greshwin. Welcome to the committee.
Thank you, Mr.
Take your
Chairman.
name for the record and proceed.
Yes, thank you, Mr. Chairman and members of the committee. My name is Steve Yock. I'm an attorney and lawyer in Minneapolis. I'm grateful for the opportunity to talk about this bill. I have represented many dozens of general contractors and subcontractors over the year, and I've written a lot on real estate and construction issues. In the 30 years that I've practiced in this area, I've never spoken to this legislature about a bill before. But I believe that the proposed bill represents, for many of our small contractors, as you just heard from the prior speaker, an existential threat, and especially, which has not been discussed today, the impact on single-family housing, which is already a very tight market, and there's limited affordability. As you may likely know, Minnesota is one of the most heavily regulated areas for, again, I'm going to focus on single family. I think it's worth noting that that has really not been discussed much through the course of these proceedings, but we have a very rigorous 327A statute, which does put responsibilities on the general contractor to monitor and make sure the subcontractor's work is required. Likewise, Minnesota requires that if an owner pays a contractor money to pay to somebody else, it's held in trust. And if they don't give that money, they're subject to criminal liability. So we have layers of protection for both homeowners and for contractors. And of course, we've talked a lot about, and I'm not going to repeat the discussion of Chapter 181, the theft by contractor statute, which is appropriate and should be enforced. The current statutory framework that's discussed in this bill presents there already is substantial protection for homeowners that I don't believe is necessary, but there are things this bill will do. This bill will compel small businesses and to review their subcontractors' records and assume fundamentally something that they don't have responsibility for, that is, interacting with the individual employees of the subcontractors. I would also note, and there was some discussion about other states, this bill is not in any of our border states or a companion type bill. This will have a direct impact on single-family home construction in Wisconsin. You can avoid these costs, and some of my clients probably will, to build lower-cost single-family homes in Wisconsin that will not be able to be built in Minnesota. We will lose that business. Now, I doubt this was the bill's intent, and I'm confident it's not, but the inevitable result of this will be a further consolidation of the single home construction industry. Most of the large construction companies are from outside Minnesota, and they may be able to absorb some of these costs that are discussed here. However, the smaller contractors can't. They simply do not have the resources. This will result in less competition and higher prices. Finally, I think there's, again, a huge distinction between large commercial projects, which we've talked about today, large multifamily, and single-family home. As written, the burden places an equal burden on all those types of different contractors to understand what their subcontractors are doing, and they're just simply not equipped. This will squeeze out and cause either housing costs to go up or less people to build low-income housing, which, of course, there's a tremendous shortage. Even if a general contractor
wrap up?
Yes, even if the general contractor goes to the expense of the audit here, as was noted by Mr. Werke, there's strict liability. You can be a general contractor and do everything you're supposed to do, and you're still strictly liable. That undermines fundamental fairness. There are narrow exceptions that permit that sort of activity, but they do not exist here. That's the other stitches that we talked about. So, Mr. Chairman, members of the committee, this bill, as currently presented, will have a tremendously adverse impact on single-family homes, which has not been discussed. It'll hurt affordable housing, and I believe it's unwise and should be rejected. Thank you.
Thank you. Mr. Greshwin? And I probably said that wrong.
It's been said many ways, and you are as close as many have been. So I appreciate and thank you for that. Mr. Chairman, committee members, my name is Bill Geschwind. I'm the founding attorney of Minnesota Construction Law Services, a boutique law firm serving the legal needs of owner-operated contractors and subcontractors at all tiers throughout Minnesota. I'm an active member and supporter of Housing First Minnesota, Associated Builders of Minnesota and North Dakota, and the Minnesota chapter of the National Association of the Remodeling Industry. It's frustrating to hear the stories you're being told this afternoon. To accuse non-union contractors of rampant wage theft, of hiring immigrants only to exploit them for profits, is reckless, dishonest misinformation. If the allegations made today were true, wouldn't you be hearing about thousands, or even just hundreds of court decisions finding that construction workers' wages were stolen? I know of one case, Janice v. ASME, where the U.S. Supreme Court found that a union's mandatory dues are wage theft. You're not hearing about a multitude of wage theft cases in the construction industry because wage theft is not a widespread problem in the construction industry. What do the labor brokers this bill's proponents complain about actually do? Well, let's see. They gather up a pool of workers, they negotiate a labor agreement with a contractor, and they demand a fee from the workers who want one of those jobs. Isn't that precisely what the labor unions do? And don't those unions give the money confiscated from workers to politicians so they'll pass bills like this one, giving unions a monopoly on wage theft? On January 24th of this year, WCCO reported that over the past 13 years, across all industries in Minnesota, there were only 745 claims of wage theft reported to the Department of Labor. Of the worst cases, none were in the construction industry. In a courtroom, when a witness's statements clearly exaggerate, mislead, or lie, a jury disregards everything the witnesses say because that witness is not credible. The assertions of rampant wage theft in the construction industry are proved to be untrue by WCCO's investigation. You must ignore everything this bill's proponents are telling you and stop this bill. Our current wage theft law is widely recognized as one of the toughest in the country. For the proponents' claims to be true, you'd have to believe that the Department of Labor and the Attorney General did nothing about construction industry wage theft for the past 3 years while knowing that 20% of construction workers, mostly immigrants, were being exploited. Is that something that you can believe?
Can you come to a conclusion, sir?
One final observation. Minnesota statutes and rules mandate that subcontractors alone are responsible for paying wages and taxes for their workers. This bill conflicts with long-held laws and rules in Minnesota by obligating contractors to supervise their subcontractors' payroll and making contractors responsible for their subs' wages and taxes. Mr. Chairman, committee members, I respectfully request that you consider the facts and not the unproven anecdotes of this bill's proponents and oppose this bill. Thank you much for your time.
Thank you, sir, for your testimony. Brooke Bordson, and then I have Michelle Dreyer. Welcome to the committee. State your name for the record and proceed.
Thank you. Thank you, Chair Nelson and members. Thank you for the opportunity to testify today. My name is Brooke Bordson, and I'm with the League of Minnesota Cities, which represents 837 cities across the state. I wanted to just very briefly touch on some concerns about the bill from the perspective of cities. Under the new definitions in the bill, starting on line 3.25, a city as a project owner would be deemed a contractor in certain circumstances and liable for all claims as such. Our concern is that cities would end up using public funds to pay for certain costs twice if a contractor didn't pay a subcontractor claim or the payment was in dispute. Because public projects are funded with taxpayer dollars, municipalities are subject to unique requirements under the state's Chapter 471 Uniform Municipal Contracting Law. For most construction projects over $175,000, a city has to bid out the project and accept the lowest responsible bid. Thus, cities are not allowed much discretion in selecting a contractor, and we believe these regulations that apply specifically to municipalities should be taken into consideration when determining whether to make a city financially responsible for a contractor's actions. The Uniform Municipal Contracting Law also requires projects over $175,000 to include a payment bond. and that's in 574.26 contractors' bonds for public work. For projects where a payment bond has been obtained, subcontractors and workers can make a claim against the bond for wages they're owed. We would request that language be added to the bill stating that these new provisions would not apply to allow claimants to seek payment from a city when a city has required a contractor to provide a payment bond. Without this exception, there may be confusion about whether a claimant would file two claims or how those claims would proceed. So just in summary, we're concerned that the effects of the bill could pose a financial risk to cities as they plan for and incorporate projects into their budgets. And I really want to thank Representative Feist for taking the time several times to speak with me about our concerns. I'm very happy to work with her as the bill moves forward. Thank you.
Thank you for your testimony. Michelle Dreyer, then John Bush. And again, state your name and then proceed with your testimony.
Thank you very much. Chair Nelson, members of the Labor and Industry Finance Committee, thank you for the opportunity to testify today. My name is Michelle Dreyer, and I'm the Director of Government Affairs for the Electrical Association. My association provides education, workforce strategies, and government advocacy for my 257 contractor members, most of whom are small employers throughout the state of Minnesota. Prior to working for the Electrical Association, I worked at the Minnesota Department of Labor and Industry, investigating instances of wage theft on prevailing wage projects as well as general wage theft in other industries. As an individual contributor as well as through my team of investigators, I am responsible for recovering at least $2 million for exploited workers in minimum wage, overtime, and prevailing wage recovery. I have multiple concerns regarding House File 1859. This bill seeks to prevent exploitation of workers, which I agree is important. My concerns is the way it goes about doing so. I've been working with the author and several of the bill supporters to alleviate those concerns, and I appreciate the opportunity to do so. I have to say, in listening to the testimony today, non-payment of taxes is as much or greater concern than wage theft. I've heard many times payment of cash, which paying cash is legal, but you have to pay your taxes. You have to take the records necessary for the employees. It seems that the recurring thread here is misclassification of employees as independent contractors. And that's something I did not prepare in my testimony, but that's something that I did see in listening to the testimony of the affected workers today. Since I left DLI in late 2016, there have been many additional tools added to labor standards enforcement, including additional wage theft powers and additional documentation of wage requirements. Law requires workers to know how much they are paid prior to engaging in the work. Minnesota has strong provisions regarding the misclassification of work and require commercial contractors to register. Residential contractors need to be licensed and therefore also registered. Wage theft provisions give DLI the ability to investigate over and above minimum wage. I'm not testifying for Minnesota Department of Labor and Industry, but I do understand the complexities of wage theft and the skills necessary for a successful investigation. DLI does a great job of investigating and collecting on wage theft.
You can come to a conclusion.
And is best suited for examination of records and compliance and issuing of withholding orders. The investigators also have special training regarding data practices and the sensitive data contained. So one of the things I've seen in listening to the other people's testimony today is I do believe that DLI is central to address some of the problems that we have heard here today, but there needs to be some good collaboration between unemployment and taxation agencies in order to address the issues that we've heard. Thanks so much for your time, and I will make myself available for questions.
Thank you, Mr. Ryer. Mr. Bosch? Or Boucher, welcome to the committee. State your name for the record. And this is our last testifier.
Thank you, Mr. Chair, and again, members of the committee. For the record, John Beshy, Associated Builders and Contractors of Minnesota, and thank you for the opportunity to testify on this bill. ABC is opposed to House File 1859 and the requirement that general contractors assume liability for any unpaid wages or fringe benefits owed by a subcontractor of any tier. When the 2019 wage theft bill was signed into law, advocates celebrated it as one of the toughest wage theft laws in the country. It was supposed to provide the Department of Labor and the Attorney General with the tools needed to crack down on wage theft, and it created criminal liability for intentional fraudulent wage theft. Now, I want to be absolutely clear that ABC does not condone wage theft, and we believe that every worker deserves to get paid. However, House File 1859 paints all general contractors with a broad stroke and will punish merit shop contractors while providing carve-outs for union contractors and contractors on prevailing wage projects. If an employee takes legal action against a subcontractor of any tier, this bill will make the general contractor jointly and severally liable for unpaid wages, benefits, and liquidated damages. If that subcontractor is unable or refuses to pay, the general contractor will then be stuck with those costs. This assumption of liability is unfair to general contractors who have no knowledge of what may have transpired between subcontractors and their employees, or even what will happen in the future. The general contractor does not sit on the HR or accounting divisions of the dozens and dozens of subcontractors that they work with on every single project. The ultimate effect of this bill will be to punish innocent parties for the bad actions of others. It's been said that this bill is needed to tilt the playing field so that it is even between general contractors and employees. However, ABC is concerned that this approach seems to only apply to non-union general contractors, as the bill explicitly permits the assumption of liability to be waived by a collective bargaining agreement with a trade union. We were able to quickly review the author's amendment prior to committee, and while we do appreciate that it adds some more clarity and specification regarding the CBA exemption, we remain concerned as to whether the Department of Labor will have any oversight or enforcement mechanisms to ensure that proper wages and benefits get paid. From a practical standpoint, we are concerned that if the liability requirements in this bill can be waived by a collective bargaining agreement, a merit shop general contractor who hires a union subcontractor would still have to assume liability and could be held jointly and severally liable for those wages. Even if the union subcontractor CBA includes a grievance process, could a merit shop general contractor still be held jointly liable for wages? If so, the likely result will be that merit shop general contractors will avoid doing business with union subcontractors out of fear that they may need to assume the liability for unpaid wages. If the trades unions here are okay with that idea, we can let our general contractors know. In closing, again, ABC believes that every worker deserves to get paid, and we would like to see DLI enforce the wage theft laws that are currently on the books and hold the bad actors accountable for their actions. In closing, we urge the committee to vote no on House File 1859. Thank you again, Mr. Chair and members of the committee, for the opportunity to testify.
Thank you. And members, just so you know, we're going to move House File 2213 till next week. We're going to finish this bill up today. I've got opening up for discussion. I have Representative Myers, first person.
Thank you, Chair Nelson. I just want to say thank you to all the testifiers and really say thank you to Representative Feist. You know, I love to hear when people come in here and say that you're willing to meet with them and you're talking to all different sides. I will say I've had many conversations, several with Mr. Dunnick, advocates, carpenters, general contractors in regards to the operation of this bill. And I appreciate everybody advocating and looking at all the different sides. You know, what I will say is that every single person should be compensated for their hard work, and, you know, general contractors shouldn't be unjustly enriched for employees not being paid. The question I have specifically for you, does this bill address that if a general pays the subcontractor all, you know, the money or a lot of the money already for the services provided, does that mean that the employees can still come back around to the general contractor so that they're already, you know, if they've already paid once or a majority of it once, they're going to come back around and have to pay it again?
Representative Feist.
Yep, thank you, and thank you for the question. So this bill covers the relationship between the general contractor and the subcontractor. And the workers to the direct employer. So your question is, will the workers then be able to like skip up and sue the general contractor as part of this bill?
So
Representative Myers.
Thank you. I reached out to, a few generals, and they said, the way that we run our business sometimes is that we pay our sub the amount to get the work done. If that work gets done, but the sub doesn't pay their employees, now I'm going to be left with the employees coming back up to me again. And so now I'm left, with 2 bags that I've paid. And I just didn't know if this is addressed in that bill. Again, it's an operational question.
Representative Feist.
Yep. Thank you, Mr. Chair. I feel like that is not how this bill functions. I feel like that is more of just general commercial litigation. And I would be happy to turn it over to Mr. Dunick, who I don't know. Would you be able to answer that on a more technical level? Forgive me, I am a lawyer, but I'm an immigration lawyer, and I don't know the answer.
Welcome back, Mr. Dunick. If you can quickly answer.
Thank you, Mr. Chair. And Representative Myers, I don't know the exact answer to that question. My understanding is that under most circumstances, there would be an agreement between the general and sub about the timing of payment. So in general, what we see in our industry is that the contractors don't pay the sub before the work gets done. They pay it in phases or in stages. And that sort of arrangement would be worked out between them before workers. So there wouldn't be a situation where subs have been fully paid, but then their workers aren't paid.
Representative Myers.
So what I would ask is if Representative Feist would be able to consider that situation, because that, again, I'm not going to take credit for that, but I've talked to a few contractors that said that is the case with some of the people that they do work with. So again, we want to make sure workers are paid, that general contractors aren't unjustly enriched. But I would like to see if potentially we could look into taking that into account.
Representative Feist.
Thank you. We definitely want this bill to function as intended, and I would be very happy to work with you and with other lawyers who don't just practice immigration law to make sure that this all plays out appropriately. So thank you for that feedback.
Thank you.
Representative Mecklen.
Thank you, Mr. Chair. Sort of similar question for the author. If a sub that I hire, and I have a contract, I have a subcontractor agreement with them, I have a contract with the building owner, usually the homeowner in my case, and if my sub who does exteriors, he may hire a sub who does metal bending. So under this, if my sub does not pay that sub, would I then be obligated to pay that sub?
Representative Feist.
So the way this bill functions is that we are placing the liability with the person at the top of this pyramid of contracts and subcontracts, and that would be the general contractor or the owner who enters into those agreements. And so yes, we are placing liability on the person, the party with the most control over ensuring that there is no wage theft.
Mr. Chair. So under that scenario, that's exactly how I read this as well.
Mm-hmm.
The interesting part is I keep hearing about wage theft, which nobody likes, but that second layer sub is an invoice. In that invoice includes all his metal. It includes his insurance cost. It is not solely all wage. Who is going to take the ownership to figure out how much of that would have actually been his wage? And if I've already paid my sub that has allegedly not paid him, then I have to pay it again. Is that not stealing my wage?
Representative Feist.
Yep. Thank you, Mr. Chair. Thank you for the question. So this bill provides power to the general contractor to have access to the information that they need to ensure that the subs beneath them are not engaging in wage theft. And so there's access to actual records. So we are putting information and power along with that liability into the hands of the general contractor to ensure that they are able to identify wage theft when it occurs. And we're placing that responsibility on the general contractor as well.
Representative Mecklen.
Thank you, Mr. Chair. Doesn't this strongly conflict with the 9-point subcontractor agreement or checklist? That you are basically telling us that we have full knowledge and authority over everything that they do below me when they run their own private business? Aren't I being forced to interject myself into their private business, which at what point are they no longer a subcontractor?
Representative Feist.
So my understanding of the way that the industry works, and industry experts can jump in, is that there's a lot of transparency already when people are placing bids, so that they understand, how much the drywall hours are going to be billed out at, how much the material is going to cost. So a lot of this information, while they might not have it on paper, is a known set of data when they're deciding which subcontractors to hire. So we are providing them access to documentation to ensure that the subcontractors are ethically and accurately reporting their costs. And that is what we're doing here. So that information is not private, secret, proprietary information. It is already information that the parties entering into this contract have access to. And Mr. Dunnick can correct me if I'm wrong here, but I believe that's how.
Mr. Chair, Representative, if I could try to attempt to answer the question the other way, which is to say, the other situation we see is where there are just layers and layers of subcontracting that are just intentionally done to confuse who is an employee, who is not, whether they're an independent contractor or whether or not, who they work for, who's making decisions about their time and schedule and those sorts of things. So that's what we're trying to get away from.
Representative Mecklen, one more question. I've got other people who have questions.
Well, Mr. Chair, I appreciate that. But this is a very complex bill that is going to affect a lot of things. And I think all these questions are pretty important. Can Tim Werke come down and help answer this question?
Mr. Werke, quickly. We're running a little over time here, and we've been granted some.
Yes, Mr. Chair, again, for the record, Tim Werke, Associated General Contractors. I can answer this very quickly. Yes, that's how we read the bill, that a general contractor would be responsible for lower tier subs who criminally violate the wage theft law, assuming that responsibility up onto them, jumping over what would be called or termed second or midterm subs. You can have a general who subs to a sub who subs to a sub, and that sub down the chain who commits the wage theft, according to our read of the bill, would jump over, the liability for that payment would jump over everyone else in the string to the general contractor. And the general contractor cannot procure an insurance instrument to protect against that.
Thank you, Mr. Werke. Representative Greenman.
Thank you, Mr. Chair, and I guess I have a question for you before you leave, Mr. Werke.
She's got a question.
Can you point to me where in the bill it discusses your concern about criminal liability?
Mr. Werke.
Madam Chair, I say that in respect to the 2019 wage theft law, which criminalized wage theft, made it a criminal offense versus a civil offense.
Representative Greenman.
Thank you, Mr. Chair. I understand that there's another law in the books, but this law has to do with civil liability, and you're talking about how it impacts criminal liability. I, one, think that would be a constitutional problem. I also don't see that in this bill.
Madam Chair, Representative, I guess I mean that in the context of the criminal action of the perpetrator of the wage theft. And the action would be the thieving of the wages that the now upstream general would be responsible for paying, and would, from the general's perspective, have already paid those wages by paying their subcontractor. And again, in this bill, it allows up to a 3-year cause of action to be brought, so that subcontractor could be out of business or have closed their doors for 3 years, and a claim could be brought to that general contractor for the non-payment of those wages for which the general had already paid that sub for those wages, and now would be responsible for paying those wages and penalties a second time.
Representative Greenman.
Thank you, Mr. Chair. And I think we need to be really clear about when we're talking about criminal liability versus civil liability. And I think that this bill is very clear that it impacts civil liability. I also just want to point us to the provision from the previous conversation about sort of responsibility, because we've talked about that before, right? The responsibility of general contractors and subcontractors. We talked about that in the context of the duty to defend. But here, if you look at 4.18, the provision of this section does not prohibit a contractor or subcontractor from enforcing a contractual provision or other lawful remedies against a subcontractor for monetary damages incurred by the contractor pursuant to this section. I think what this bill does is it says if the subcontractor is not paying people wages, if they're not doing that, the general contractor has legal remedies to go get it. But in this context, the general contractor is in the best position to enforce those, to have that, ensure that those rights are being enforced. And then the other thing I would just say is, I think it's really important. One, thank you, workers, for folks who shared their stories. But what's really important is that these big contractors are making money off of the behavior and the misconduct of subcontractors. Because when these contracts are being bid out, right, they're being bid out based on this conduct. So the general contractors absolutely have a responsibility to be vetting what their subcontractors are doing. That should be based into the price that they're asking for. And so I really strongly support this bill. I think that this gets it right in terms of civil liability. And I think I think what we heard, the best force of enforcement is compliance, and that's what we're hopefully doing here. So I really appreciate that, the bill, and just wanted to make sure we corrected the record about what the bill actually does.
Representative McDonald.
Thank you, Mr. Chair. Just for the record, not all big contractors are big companies. Many are family-owned businesses. I have several in Wright County. But I have a couple questions for the Commissioner of Dolly. Lisenbeck, if she's available.
Ms. Listenbach, if you come down and again state your name for the record, and we're going to get another 5 minutes here, and then we're going to vote on this bill before 2:15. So.
Very good. Thank you, Mr. Chair.
Chair Nelson and Representative McDonald, my name is Nicole Blissenbach. I'm the Commissioner of the Department of Labor and Industry.
Representative McDonald.
Thank you, Mr. Chair. Commissioner, thanks for coming down. Subcontractors work very hard in their profession, be it electrician, plumbing, construction, block lane, you name it. They have a reputation as well. And if they're not paying their employees, then they won't be in business much. I have many family and friends that are in the trades, and especially in a small community like Wright County and Delano, you do the hard work, you pay your employees, and you will have a successful business ongoing for many years to come, especially the trades. Are you kidding? You're going to do fantastic. I'm very happy that my son is in the plumbing industry, and he's doing very well at 23. But I digress. You know, how many of these cases are being reported to Dolly? And I'm not going to beat up on Dolly at all. I think you're doing good work, and I presume you're still doing good work, because in 2019, we passed the toughest laws in the nation for wage theft. And I think you have 7 new investigators, I believe, 7 or 8. And I don't know how many millions of dollars that were allocated in 2019. I hope I voted for that in 2019. I'm sure I did. But I'll look later. But with, I think it was $3 million appropriations.
Get to your question.
So what percentage of their bad actors out there? And if so, if there, you know, we hear some testimony, are the investigators doing the work and investigating for the claims that there's wage theft going on in Minnesota, and especially in the construction industry, because Representative Feist's bill pertains just to that.
Commissioner.
Chair Nelson, Representative McDonald. So we do investigate wage theft claims in all industries. We have investigations in, I would say, almost every industry. I feel like it does touch on the department. There are specifically challenges to investigating wage theft claims in the construction industry. Some of those were touched upon by the testifiers today. I'll just touch on a couple to be short. Sorry, Chair. One is, as I think you heard from a number of testifiers, oftentimes in the construction industry, it's hard for an employee to even identify who their employer is. And that is because of the construct of the multiple layers that are existing in the contracting on a project. So that's one. And the current law, the way it works is it's the employer who's responsible for the wages. So if we can't identify who that employer is, or once we do identify that employer is gone, bankrupt, can't be contacted, it makes the likelihood of recovering those unpaid wages virtually zero. And so that is a challenge that we face, especially when we're investigating allegations of wage theft in the construction industry, just because of the challenges that are unique to that industry that we don't see in other industries.
Representative McDonald.
Thank you, Mr. Chair. And then, Commissioner, how often is that happening in the last, I'll give it maybe 3 years? Since 2019, we passed it, give it a year to get acclimated. So we got 3 years. How many reports and investigations have you done in the industry regarding wage theft?
Commissioner.
Chair Nelson, Representative McDonald, I can't give you a number. I would have to go back and check on that. You know, we investigate claims as they come in. We have to, as complaints come in, we always have to consider our resources. And so if we are looking at a complaint and we see that there could be something there and we look into it and we determine that the likelihood of recovering wages is not there, that is something we take into consideration in determining where we're going to go with a complaint. And I feel bad saying that, to be honest, but our resources are what they are. The challenges that we have in certain industries are what they are, and we have to work with that.
Final question, Representative McDonald.
Final question. Commissioner, so if Dolly is having a hard time finding who these subcontractors are, employers, don't you expect that it would be very difficult for the general contractors also to do so? And in this case, if our own Dolly, who has tax dollars and millions of dollars and several investigators to find out who these subs are, it seems very unfair that the general contractor should be expected to do so as well if this Representative Feist's bill becomes law. Seems to be very unfair, wouldn't you agree?
Commissioner.
Chair Nelson, Representative McDonald, I do think that there are the contracting that is in place in the construction industry where you do know who you're contracting with. I think it definitely puts a general contractor and subcontractors in an advantage in determining who's responsible for what work on a construction project.
Representative Feist, if you want to give a wrap-up.
Mr. Chair, before Representative Feist speaks, I would request a roll call on House File
Roll
1859.
call's been requested. Representative Feist, if you want to give a wrap-up.
Yep, thank you so much. So
Briefly.
I have 5 points, but I put a 4.5 between 4 and 5, but I'll be efficient. So I just wanted to highlight a moment that we had here where we had 2 workers come and share their stories of wage theft that happened to them and family members. And then we had another testifier get up here and say, there is no wage theft. They said, why are there thousands of cases? And the reason there are not thousands of cases is because people aren't listening to these voices. They do not have power in this dynamic. They oftentimes are relying on their employers for their housing. They are uniquely vulnerable and uniquely voiceless workers. And I'm not saying that all general contractors are bad actors, and I don't think anybody wants wage theft to be a thing in this room. But there is something about the business model that is uniquely vulnerable to wage theft because we do have these layers of contractors, subcontractors, subcontractors. And so we need to be uniquely proactive in addressing wage theft in the construction industry. Civil liability is a strong motivator. We have tried to also go criminal liability route. That really hasn't worked out, as Representative McDonald's questions really highlighted. And we need to do more, and we need to do better by these workers. California passed a similar law the longest ago of the many other states that have passed laws like this. The sky did not fall. Small minority and business women-owned subcontractors still exist in California, and wage theft is down. So this type of law has proven to be effective in other states, and I'm excited to bring it to Minnesota. As you've mentioned, I will talk to anybody. I will continue these conversations. I believe in good governance. I want this bill to function as intended. I'm a business owner. I have a law firm, 10 employees, so I don't want to create chaos for businesses, and I'm excited to continue those conversations. This bill is really important. We are putting power with the workers who have the least control over their situation, and we are putting responsibility on the hands of general contractors who have the most power and information. We are giving them more information and access to the documentation that they need to know that they are contracting with ethical subcontractors. And I would encourage everyone to support this bill. Thank you.
Thank you, Representative Feist. And members, to the person that said it's not happening in the industry, back a couple of years ago when I was an apprentice, it happened to me. And it happened to the contractor I worked for. And so I've witnessed this on firsthand, and so with that, Mr. Baumann, would you take the roll?
Chair Nelson.
Aye.
Nelson, aye. Vice Chair Berg.
Aye.
Berg, aye. Lead McDonald.
Nay.
McDonald, nay. Representative Daniels.
Nay.
Daniels, nay. Representative Greenman.
Aye.
Greenman, aye. Representative Hill.
Aye.
Hill, aye. Representative Hussein.
Aye.
Hussein, aye. Representative Jordan.
Aye.
Jordan, aye. Representative Koslowski.
Aye.
Koslowski, aye. Representative Meckland.
Nay.
Meckland, nay. Representative Myers. Aye. Myers, aye. Representative Schultz.
Aye.
Schultz, aye. Representative Wolgamott is excused. Mr. Chair, with the conclusion of roll call, there are 9 ayes and 3 nays.
9 ayes and 3 ayes, the motion, and I bid say this, that I renew my motion, that House File 1859 be referred to the Judiciary, Finance, and Civil Law Committee. And with a vote of 9-3, the motion prevails.
Do we have copies at 3?
And members, with that, we are adjourned.